As it relates to this, I want to make certain that we have this discussion. States' rights and balance of power, checks and balance between executive, legislative, and judicial branch of government. One of the areas that this constitutional convention would look into would be overriding Supreme Court decisions, correct?
It could potentially discuss mechanisms by which the states could now decide their concurrence or non-concurrence with Supreme Court decisions.
And the legislative branch of the states would make that decision concerning a judicial decision by the U.S. Supreme Court, right?
The 50 states would have to do so potentially. That is a possibility.
And based on my notes, about two-thirds majority of the states could override a U.S. Supreme Court decision. That's one of the areas that you'd be looking at.
Yes, sir. Because, okay. Go ahead. I'm sorry.
Well, you've anticipated my next question. You can go ahead with the because. Go ahead.
Because the Supreme Court of the United States has decided to abrogate for itself legislative powers. Let me give some examples. It was not a convention of states that changed the definition of marriage. It was not a convention of states that decided that life did not begin until after birth. It was not a convention of states that made other decisions. Does the court have a proper role and function? Yes. But I believe, particularly given the change that the 17th Amendment made, that changed the customer of the United States Senate, we now live under the consent of the appointed, not the consent of the governed.
Okay, so you pointed out several areas where you think the Supreme Court overstepped their constitutional boundaries.
Yes, sir.
Do you believe that they overstepped their constitutional boundaries when they dealt with civil rights type issues?
Let me give you an example, if I may, of what my concern is. In 1875, a Republican Congress passed the first desegregation law, later overturned by the court. In 1884, a Republican Congress passed its second desegregation law, which eventually led to Plessy versus Ferguson in 1896 that gave us separate but equal. In 1954, the Supreme Court gave us Brown versus Board of Education. That decision is hailed as a landmark civil rights decision.
It is.
And I agree with that. Here's what my example tells you, though. The people of the United States in 1875 were already passing desegregation laws to ensure that ancestors of your melanin were not going to be discriminated against. The people spoke through their representatives in 1875. But it was not until 1954 that the court caught up to the people. Your ancestors sat in desegregation for 75 years because the people spoke and the court ruled it unconstitutional. While Brown versus Board of Education is a landmark decision, what it really tells us is when you put legislating in the hands of the judicial branch, it will exacerbate and lengthen what's the word I'm looking for, Senator? I want to be very careful, very deliberate here. It lengthened the amount of time that your ancestors were treated as second-class citizens. The court caught up to the American people 70 years later. That's 70 years your ancestors could have been equal partners from 1875. But you did not become equal partners till 1954 because we treated the Supreme Court as the supreme arbiter of the law. They have a proper role and function. But the people of this country are who we consent to, not the appointed.